Mr. Tootin, you may approach the well.
Good morning.
Good morning.
May it please the court, Attorney Terrell Tootin on behalf of the appellant. I'd request 3 minutes rebuttal.
You may proceed.
Yes. On this matter, the issues that we focus primarily on are all pretrial. I don't believe anything really happened during the trial that was concerning, or at least not concerning enough to raise issues on appeal.
Your second issue, the in-court identification?
Yeah, that, I guess is based on the pretrial suppression, but yes, thank you for correcting that. There's a pretrial, we had a motion to suppress pretrial that was done in the in-trial identification. Our argument is based on the fact that the suppression was granted pretrial, that it should not have happened during trial. But starting with the first issue, that there was a motion to suppress. So I believe I did 3 different motions to suppress on this case under different grounds. One of the motions to suppress was a motion to suppress the defendant's or appellant's statement. That was the statement made to the police in interrogation where he initially denied any involvement and ultimately stated that he was involved, at least in some capacity, in the killing that occurred on this. Now, is our contention that the statement was not voluntary, and this was a juvenile at the time, and so the standard, as we cited too, as it relates to juveniles, when we're determining whether or not the statement was voluntary, is you look at the totality of the circumstances, but number one, you look at the circumstances surrounding the interrogation, including age, experience, and intelligence. We think that is a major factor that happened, that we were focused on. Number 2, the juvenile's capacity to understand Miranda and consequences of the waiver. Number 3, the juvenile's familiarity with Miranda and ability to read and write. Number 4, any intoxication. Number 5, any mental disease, disorder, or retardation. And number 6, the presence of a parent, guardian, or interested adult.
So,
now,
Mr. Tootin,
yes.
let's, because it seems to me at the end of the day, your best point is the mother not being around.
Okay. So,
I mean, because let's just go through these.
Mm-hmm.
Age, well, he's a month away from being 18.
he was.
So yes, he's still a juvenile, but he's a month away from no longer being a juvenile. So it's not like he's 13.
Correct. He was 17.
He went through 11th grade.
Yes.
This wasn't his first run-in with the police. He has prior experience dealing with police.
He does, but I do think it's important to note that even the trial court in its order acknowledged that there was no evidence that supported that the juvenile was familiar with Miranda. I believe he had 5 prior juvenile matters, and the court pointed out that there was nothing presented that showed he either had a lawyer or any familiarity
But this
with
isn't,
Miranda.
I mean, I understand the trial court's finding, but this isn't his first run-in with law
Correct,
enforcement.
because I'm understanding it was at least 5 prior
He wasn't
juveniles.
intoxicated.
Nothing to support intoxication.
There's no proof that he was denied the bathroom, food.
Correct.
They kept him overly cold or overly hot. They didn't chain him to a table. They didn't threaten to beat him with the phone book. None of that's present.
Now, I believe he had an ankle.
Right, but I mean, when I say, he wasn't completely confined.
He wasn't
okay?
completely confined.
He was advised of Miranda. He did at least acknowledge that he understood it and signed it, correct?
And that is according to the officer.
Well, I mean,
testimony.
does the record not contain a signed Miranda statement?
I mean, it does.
Okay,
but,
so, I mean, I can't look at that and say he didn't understand it if he signed it and said he understood it. I mean,
the only reason I highlight that's according to the officer, because as the court may be aware, is there's different points in the brief where we think the officer has made statements that were inconsistent in such a nature to where that would be a factor in determining that credibility.
so let's go to the mother, because that's where, again, where I think because I think based on how we have to review the record,
I understand.
we check a lot of boxes here that don't check in your favor. But the mom issue is a different issue. So I want to make sure I understand the timeline here correctly. They had, and I think the state says this in their brief, and that you would agree they had probable cause to pick up your client.
Yes, before they even picked him up, there was probable cause.
All right. So they pick him up with probable cause.
Correct.
They called the mother, did not get her, and left her a message. Is that correct?
I believe so. I believe the
Okay.
mother, there was a lot of consistent testimony regarding that.
And they didn't start interrogating him immediately.
They did not.
They called again when they hadn't heard from her. And during that phone call, she said, I have to take a test or I have a class or something like that. You go ahead and talk to him.
That is disputed.
Well,
The mother testifies explicitly that she did not agree.
right, but the trial court seems to have disagreed with the mother's testimony.
Correct.
Okay.
I think he
Well,
gave.
and I say that
Yeah.
because we can't make a credibility
No,
determination.
I understand that, but I think that, the trial court, I don't think said that the mother lacked credibility or things of that nature. I think what the trial court did, if I remember correctly on the order, which starts in volume 1, I think it's pages 15 to 21, the trial court uses the statement straight from the transcript about what the mother said, and essentially said this appears consistent with what the officer said, not inconsistent. So I would ask the court to review that. I don't believe the trial court said the mother was not credible as much as the trial court concluded that the statements.
Well, if
in
she's
essence-
consistent with what the officer said, and the officer said, I called, and she said, go ahead and talk to him, then the trial court made a finding that that's what she said.
Well, see, and that's the problem. I don't believe that it was a credibility, I don't believe the trial court thought the mother was being dishonest. I think what the trial court concluded was, when I read this statement, and then the statement was included in the order, I think the trial court concluded, I don't really know if this is anything different than what the officer's saying. What I'm submitting is, I think it is very different. So it would be one thing if the trial court said, the mother's not being honest, I don't find her to be credible, and here's where she said something that is just not plausible to me. What I understood the trial court to say is, I actually don't see that she's actually saying something that's all that different than what the officer said. So I think this court now has the
You've really
opportunity to determine.
Flipped it entirely, Mr. Tooting. That is not at all what the trial court order says.
Okay.
That's just not true. So I want you to back up a little bit first. And, first in Tennessee, a juvenile is not required to have a parent during the questioning or interrogation. That's accurate, right?
It is a factor, but it is not, the
No, that's
absence
the
of
law.
it does
That's
not
the law.
automatically
That's the law.
exclude anything.
Right, but you agree with me that that is the law as it stands right now?
I agree that.
Even if we don't agree
Yeah,
with it.
I just want to be clear, I agree that it's, I agree it's a factor, but it's not an automatic, like, I don't get to say, well, this one is missing and therefore it's automatic.
Right,
It's
but you
just a
didn't engage
factor.
in any weighing analysis in your brief. The only thing you really focused on is one factor, one of those factors, and that's the fact that there was no parent present, right?
That was one of the factors I focused on. I think I've also focused on number 1, which is the circumstances surrounding the interrogation. Because here you have a mother saying, I'm en route, trying to get there.
Again, you're misstating the facts. That's not at all what this mother testified to. The mother testified that she had to take a test. She was going to call the officers back. The officers waited, and the mother didn't answer their call. The mother didn't go to the police station until 7:20 p.m. At least that was the timeline that was set out by the trial court.
Okay. And so when I say that the mother had took the position that she didn't want the defendant or the appellant questioned without her being there, and I understand the court may have a different reading, I want to be very specific why I'm reaching that conclusion. Volume 5, page 75, lines 1 to 2. I interpret that language clearly. And again, if your honors disagree with me, I at least want you to see
It's not
where-
us disagreeing with you.
Well,
The
I
trial
think
court disagrees
well,
with
the
you,
trial
and that's
court-
what we're
the trial
that's what we're
court
bound
did
by.
disagree, but what I'm saying is the record that I'm relying on. So when I say the mother explicitly said that, I'm basing that off the testimony from the mother under oath. Now, I can appreciate if the trial court says.
Here's what the trial court said in its order.
Okay.
He quotes the detective, and then he says, now the mother earnestly contends that she indicated to the officers to be present immediately. However, her statement at the hearing indicates otherwise.
Okay.
So you can couch that however you want,
Yeah.
Mr. Tootin, but to me, I'm gonna go ahead and tell you, that's him saying that what she testified to is different than what the officer is saying. And so then he ends up denying your suppression motion, which the implication there is he did not believe the mother.
And,
Okay.
and the only other thing that I'm concerned about your brief, Mr. Tootin, is the weighing of the factors, that even if we give you the benefit of the doubt, and we say, okay, Mr. Tootin, we agree that the trial court got it wrong on that one factor about believability of the mother, okay? That's one factor in light of all the other factors that we are to consider. Age, that Judge Dyer was going over, age, intelligence level, previous experience with law enforcement, any prolonged questioning, which in this case doesn't apply, length of detention doesn't apply, advice of rights applies. All these other factors weigh against your argument that it wasn't voluntary or a coerced statement. And that's the process that we as a court have to engage in, the weighing of all of those factors. The one factor that you argue weighs in your favor is that this 17-year-old juvenile was questioned and gave a confession without his mother present. And even if we give you that, all of those other factors weigh against you.
So respectfully, I disagree that all the other factors weigh against me. But specifically, what I'm referring to is I think factor one, the circumstances involving the interrogation.
Where is that?
The first factor, the circumstances, including the age. You saying where is it as far as in the case?
Which one of those factors do you think, other than the mother?
I think the first factor is supportive, looking at the circumstances.
Okay.
And the reason it's supportive, go ahead, I'm sorry.
Okay, so when you say the circumstances, what do you mean?
So looking at this, again, under the totality of it all, and the circumstances surrounding the interrogation.
I'm going to need you to be specific.
Yes, the mother expressed that she was on her way, or at least attempting to get there. So even if it's concluded that we're going to give the trial court's conclusion as a credibility issue that she said to go ahead and start without her, the message that was relayed to the defendant was that the mother was not, that the mother was basically not going to be there and that they could go ahead and interrogate him. So the image or the impression that the defendant is left with, or the appellant, is that no one is, my mom doesn't even care. My mom doesn't even want to come here. My mom is not even trying to assist me. That is not an accurate characterization of what was occurred, even under,
I think we're still missing here. Judge McMullen's question to you is, even if we give you, so you keep saying the circumstances, and
Correct.
The circumstances, then what the court's doing is says the circumstances, the totality of the circumstances, and then they give you all these factors to look at. The parent is just one of the many factors. And so what Judge McMullen is asking is, even if we give you that, even if we give you, hey, look, the mom wanted to be there and the kid was told the mom didn't want to be there, that's an issue. You still have age, education, the circumstances such as whether or not he was denied food, the bathroom, water, the length of the interrogation. Which one of those,
Yes.
even if we give you the mom, which one of those goes for you?
And I, with the framing of that question, I think I understand where we're saying essentially similar but different things. It is my contention that the issue relating to telling the juvenile that the mom doesn't want to be there is not the same as just saying the presence of the parent. The fact mom wasn't there is the presence of the parent.
Does them telling him his mom doesn't want to be there, does that change his age?
No, but that goes towards the
education. Does it change his education
No.
level? Does it change the length of the detention?
No.
Does it change whether they denied him food, water, or the bathroom?
No.
Okay, so it doesn't change the circumstances. It's one circumstance.
So I disagree, we, on behalf of my client, disagree. We think that does change the circumstances when you're representing to someone to do a knowing.
Okay. Mr. Tootin, and I could be wrong, the case law that you cite, or the state cites, under Clymer, all of these things, understand, we're bound by law.
I understand.
We're going to go through a weighing process
I
again.
understand that.
And I'm looking at you, representing your client, to tell me, Judge, these are the factors that weigh against the voluntariness of this statement.
Mm-hmm.
And the only thing that you've shown me is he did not have his parent present. And I'm asking you, what else? And you still have not given me what else?
And so what I'm saying is, number 3, the familiarity with Miranda. I think even the trial court acknowledged that there was Nothing presented to show he had familiarity. So that's another factor. That's explicitly listed as a factor. But what I'm also saying, and again, I understand if it's disagreed, but what I want to be clear on is when the mother not being present, I think that's one factor. But I think it's a separate factor when you represent to the juvenile that mom basically has no desire to be here, and that we're going to question you because mom essentially is not going to make an effort. It sounds like even from the testimony that is agreed with, mom was constantly staying in touch with the officers. It is, as far as they were calling, she would call back. I think at one point they said she had a flat tire.
After an hour when they had to call her back?
Correct. Well, I guess.
And then she said she had car trouble.
Correct.
And she went ahead and went to class. Do you really think that's a fair representation?
I think the issue is the defendant is not getting this information. If the defendant is sitting there being told that mom is not interested, basically, in coming to help, or whatever the exact language, that was not a direct quote, that's me paraphrasing, and that's the only version he gets, I think it's reasonable if I were to hear that, and I'm not even 18 years old, I'm a lot older, if I were to hear that, I'd think that they weren't coming and they didn't care. I'd get a very different impression if I was told, oh yeah, it was an hour, but then your mom did call back, she says she had a flat, she's en route. I think that type of language is a very different impression than just saying, okay, she's not coming. And so that's why I think that gives you factors 1, 3, and at least that's why I believe they're there.
You're about to run into your rebuttal
I did.
time. Let me ask you a question. The state raised in their brief that your second issue is waived.
Which issue?
Your in-court identification issue. That's your second issue in your brief, correct?
The illegal detention was the other issue that I also, that basically, and that's a quick one, he was held for 5 hours, or over 5 hours, and if the state's contention is that.
I don't have your brief in front of me.
Okay.
You did not challenge the in-court
I
identification.
did, that was a third issue.
I'm sorry, your third issue then. I
Yes.
misstated the number. The third issue, do you agree or do you concede that that was not included in your motion for new trial?
I double check, it may not have been, I don't, to be honest, I don't recall. I'll know by the time I come up for rebuttal.
Well, my
I forget.
point is,
But
the
yeah.
state addressed that in their brief, in response to your brief, and you didn't file a reply brief.
Okay.
Okay, and so what we're doing, I mean, consistently in this court, at least for
Yes.
the past, I don't know, 4 or 5 years, if you're not filing a reply brief when the state argues that an issue has been waived, meaning it's not included in your motion for new trial, it wasn't addressed in your brief for plain error, it's waived and we're not addressing it. So my question to you is, do you concede that it's waived? And if not, how are we supposed to address it if you didn't argue plain error?
Okay. I know the courts to respond, they can consider on plain error, but if it can be considered
We can't make
waived.
up arguments, though.
But it could be considered waived. That's fair. I mean, I think that's a fair interpretation of the law. It can be considered waived if it's not included. And
So
so
do you
I
concede
concede
it?
that. I concede that.
All right, thank you.
And the other one, like I said, is the in-court or the in-custody detention. Once he was detained for over 5 hours, I don't think the state gets to have it both ways. You don't get to say that we had the right to start interrogating him immediately because mom didn't care. And then, if that's the case, then there is no justifiable basis for waiting the 5 hours or over 5 hours. The only justifiable basis would have been had mom communicated she was still coming. But if they're knocking that out the table and saying that didn't happen, then they're stuck with a unreasonable detention.
Thank you, Mr.
All right.
Tootin.
Thank
That's
you.
your time. You still have your rebuttal time, sir. General Coleman?
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments because the trial court properly denied the suppression motion. So briefly, I do want to get into a slight factual background about the underlying offense, and then I'll dive into some of the facts of this questioning period. First, in October 9th of 2018, the defendant and two others shot and killed a 16-year-old boy. That's the charge that he was that we're here on. Police developed the defendant as a suspect and brought him into the police station for discussion. Ultimately, the defendant waived his Miranda rights and acknowledged that he was involved in the shooting, that he was one of the three people who fired the shots, and he even explained that his friends had pressured him into retaliating against the victim for a prior altercation. Now, to get into the facts of this questioning, Judge Dyer, I want to clear up a little bit of the timeline.
Please.
So the police pick the defendant up sometime around 2:30, and that's when he gets to the police station. Around that time, they call the mother, and it's the first call where she answers. And according to Detective Elrod, what her testimony was, or what she told him was, quote, "Let me find out what I can work out, but y'all can go ahead and talk to the defendant."
Okay, so that's the first, they actually get her the first time they call her.
The first time they call her, they get her. And that's volume 4, pages 9 to 10. So Detective Elrod says, we get her. She says, let me see if I can come down there. I've got this class, but go ahead. She testified at the second suppression hearing that she first claimed that she instructed them that she wanted to be there for questioning. That's on page 27 of volume 5. But on page 38 of volume 5, she admits she never actually said that. And so instead what they have is Detective Elrod's testimony that she said, let me find out what I can do about this class, but go ahead. He was still precautionary. He testifies that he waited a full hour, never heard back from her. That's when he made the second phone call, and it goes straight to voicemail. So around 3:30, 3:45, that's when they can't get a hold of her again. And at that point, they say, well, she's already told us to go ahead. So that's when they go and they inform the defendant of his rights, and they question him.
Let me, just real quick, speaking of his rights. So I have not read the transcript, but I do have the trial court's order. And in the trial court's order, the trial court says, and I'm quoting, "The defendant was able to understand the Miranda warnings given to him and the consequences of the waiver of Miranda rights." Mr. Tootin makes it sound like the trial court maybe equivocated some in an oral ruling at the motion to suppress, would be in the transcript. Is that accurate? One, is that accurate? And two, do we rely on the written order, or do we rely on what he said in the transcript?
I'm not going to say it's inaccurate. I simply can't remember from the record. I don't recall there being any equivocation in an oral finding.
Okay.
And I certainly don't think it would override the written order. It's not in conflict with it.
Okay, thank you.
And those findings are important, I think, and it found that a variety of the factors weighed in favor of the voluntariness. And so turning to this first issue, I want to make sure we're clear about what the specific issue being raised is, because it distinguishes what case law we're under. The challenge is that his statement to police, the statement as a whole, was not voluntary. Accordingly, we are under the Clymer factors. This court has already mentioned, I think, all of them, or the vast majority of them. I don't want to be a dead horse as to why all, or at least all but one, weigh in favor of it. The defendant today has pointed to a factor regarding familiarity with Miranda. That is a separate issue that has not been raised. That is whether the Miranda waiver was voluntary, not the statement as a whole, but the Miranda waiver. That is where the Callahan factors come in. And Callahan talks about familiarity with Miranda. It might be splitting hairs,
Well,
but
because I was going to say, I mean, under what we've been talking about today, it is not part of familiarity with law enforcement, or however it's worded in that case law. Is there not underlying there the ability to understand what's going on, and therefore the ability to understand Miranda? Or is that truly just, hey, he's dealt with law enforcement before, so he knows what happens?
I think it's a little bit more distinct with that. So Clymer and the voluntariness of a statement is more concerned about coercion. And so if you are familiar with police and you've been there and you understand sort of their tactics, that is what Clymer is considering. Have you been around police, or will the very existence of a police officer sort of scare you into potentially making a false confession? Callahan is, do you understand the Miranda waivers?
Miranda
I think
warnings.
there's some implicit, you still have to understand it to make the waiver. But when this court reviews the record and sees the video, the defendant did understand them.
Is there a video? I'm sorry.
No, there's not, oh, sorry.
I'm sorry, I looked. I was getting ready to say.
I apologize.
Where is it?
I am working on a different suppression case and recalled seeing that video. No, there
But you
is.
shot Judge McMullen not
you
saying,
did.
making that statement, so.
No, that is a big mea culpa. But the advice of rights form is signed. and so-
Mr. Coleman, let me ask you this. So it seems that the defense, kind of one of the layers of the defense's argument is that the lack of a parent being present permeates all these other factors, right? So, and I don't want to misquote Mr. Tootin, but because the defendant was told your mom's not coming, it somehow permeated his way of thinking of, they've given up, she's given up on me, so I'm just going to do whatever y'all say, which would go to voluntariness, right? Is that something we can even consider, one, and two, did the trial court even take any of that into account when discussing it either orally or in its order? I didn't see it in the order, but.
So I don't recall the court discussing it, and I think that's because, again, the record is more accurate, and it's been a while since I've looked at it. But I don't recall testimony that the police came in and said, we talked to your mom, and she said she didn't want to come and she didn't care. It was more, hey, we're here, we're going to get started.
And this is not like a case this panel is very familiar with, where the juvenile defendant clearly stated multiple times, I want my parent present. This is not a situation where this juvenile asked for his mother or asked for a lawyer during the questioning.
That's correct, Judge McMullen. Contrary to the Antonio Demetrius Atkinson case, which our Supreme Court is currently considering, the defendant here never said, I would like to talk to my mom, never asked for his mom, never invoked a right to counsel. So to answer your question, Judge Dyer, I don't think it can permeate through because of those scenarios where it's not something that bleeds over or something that is constantly on this defendant's mind based on the proof.
And I think maybe Judge McMullen's point that there's nothing in the record where the defendant asked for a lawyer, asked for his mom, asked for somebody, probably reinforces that the idea that it didn't permeate the process.
Exactly.
Whereas in the other case, that would be different maybe.
Exactly. This case is significantly distinguishable from that one. It seems like everything occurred by the book here, and the state would submit that all of the Clymer factors weigh in favor of denying suppression. But even if this court wanted to give some leniency and say the mere fact that the mother wasn't there, even though the proof shows that was her choice, even to the extent that weighs in favor of suppression, to your point, Judge McMullen, that balancing test, the trial court made that balancing test and commented on the absence of the mother and said that just doesn't render his statement voluntary. Very briefly, I'll get into the, third and or second issue about this in-court identification, and I want to pull a bit of a mea culpa for Mr. Tootin. So in the state's brief, our issue statement argues that this is waived, and we point out that this was not raised in the motion for new trial. But I went back and looked at my brief, and I'm not sure why I did not argue in the substantive argument that it was waived, and it's possibly because this is so overwhelmingly victorious on the merits. But just to give Mr. Tootin credit, that was not in the body of the argument. We would still submit that it is waived. It was not included in the motion for new trial, and the rules say that's waived. But even if this court wanted to conduct a merits plenary review, it overwhelmingly establishes that this very briefly, factually, this brother knew the defendant, knew him because he'd hung around the high school, knew him by an alias, and the alleged impropriety of the out-of-court statement was that the brother provided the photograph to police. So that in no way taints his in-court identification.
So, and I want to make sure I understood that. So the brother knew him by a nickname, didn't know him by the name the police asked, right? And so the brother went and pulled off of Facebook the nickname guy, which attributes the defendant. Did the police then use that exact same photo, though, for the lineup?
Yes. And so that's the photographic lineup, to be clear, was not included or was not admitted at trial. But the defendant's argument is because that is...
That tainted the whole process, right?
Correct.
I get that, but I just want to make sure I understood. They took the photo that the individual who made the identification
And put it
gave them and put it in the lineup for him to pick out of the lineup?
Was, on the timeline, so Nunu, or whatever the nickname was, and then there was a lineup that they arrayed first, and then the witness pulled the photo off of Facebook, and there was a second lineup? Is that the way it worked?
I can't recall if there was a first photographic lineup. There might have, I think there was, but before any lineup, the victim's brother says, it was the guy that I know whose name is Nunu. And I think if they show him one, then that's when he pulls it up and says, no, it's this guy. And so again, when we're challenging the reliability of an in-court statement, I think, when a eyewitness provides a photograph to the police, it's clear that he knows who this defendant is and there's no taint.
How is that, I mean, I would tend to agree with you, but I mean, what, I think if you take the defendant's argument to the extreme, it's almost as anybody who picks someone out of a lineup can't turn around and then make an in-court identification because they've already identified them and now they've tainted the in-court identification.
I mean, I think that is sort of the bare bones of the defendant's argument, and there's case law out there that says otherwise. We look at whether the in-court identification is reliable, and here it just was. I think I've covered everything that I need to, unless this court has any.
Going back, I think you impliedly answered this, but defendant says Callahan and state saying Clymer, right, as far as the factors?
Correct.
Got you.
But even under either of those.
So the whole circumstance is the first factor that Mr. Tootin argued, that's Callahan, and that's not one of the specific factors of Clymer, right?
Clymer talks about sort of I think they both talk about general circumstances. The distinction that it really points out is familiarity with Miranda itself versus familiarity with police officers and law enforcement.
The factors for Clymer and Callahan are very
They
similar.
overlap
Very
significantly,
similar.
yes, Judge. So we would submit that under either. The court properly found that everything was voluntary.
Thank you.
Unless this court has any further questions, we ask that you affirm.
Thank you.
Thank you.
Mr. Tootin, you have your 3 minutes, sir.
Thank you. Just again to clarify a few things, because again, as your honors are aware, I'm focusing significantly on the fact that the mother was not there and how that impacted the entire, where I'm arguing tainted the entire process. On volume 4, so this is page 23, line 24, and it goes to page 24, line 1. It's just three lines. But again, to be very clear about the fact that, I mean, because it goes towards some of the questions asked about the defendant is not asking for his mom like you would typically think from a juvenile, and that begs the question, well, why not? And what I'm submitting, it's because of the way they presented this information to him. My question to the officers was about that issue, and then again, starting on line 24, on page 23, the answer is, and I'll just read it directly, it's a little broken English, but it says, no, we was just relaying what you know, that we tried to contact his mom. His mom said, go ahead and talk to him, and that she had a test to take. We let him know that. That is a tremendous concern if that is the way they characterized all of that conduct that was happening for the mother trying to get there. That's our
Can I
position.
just say something? I mean, of all the cases that I've seen involving juvenile defendants and being questioned, interrogated by police, do the police officers get, in this case, do they not get any credit for at least attempting to contact this juvenile defendant's mother, waiting for her to come? I mean, they didn't have to do any of that.
And again, the problem again I have.
So you're making much more of what these detectives did when they didn't have to do any of
Again,
it.
well, if that's the conclusion, then I don't
It's
think
not
they
the
get
conclusion, it's the law.
No, if that's the law, then I think they can't have it both ways.
But
They
that's
don't
the
get to
law.
hold him for 5 years because the law says that the detention can't be unreasonable. It can't be reasonable, our position, for him to be detained that long waiting for the mother if their argument is we didn't have to wait for the mother and the mother told us not to wait for them. Well, if that's the case and the mother is adamant that you don't wait for her, then they should not, then it was unreasonable to wait for her, therefore unreasonable to leave him detained there. And then the other point I made about the court and its order, where I said they made the comment, I don't know if they were necessarily attacking her credibility. I think your honors may conclude different. In volume 1, page 20, specifically of the order bleeding into 21, this is the judge's written order. It talks about the mother now expressly contends, I believe, Judge Dyer, you pointed out, is that the mother now earnestly contends that she indicated to the officers her desire to be present immediately. And then he said, however, her statement at the hearing indicates otherwise. She testified. He then does a direct quote of her testimony. And then he says, this statement tends to support the officer's version. So when I'm just concluding that if he's saying that, I don't necessarily know if he's challenging her credibility as much as he says, this is how I'm interpreting it. I get if Your Honor say no, we think that means he's politely calling her dishonest. I get it. Thank you.
Thank you, Mr. Tootin. Thank you, Mr. Coleman. The case will be taken under advisement. I appreciate both of your arguments in the matter. Madam Clerk, you may call the next case.